In a situation where people can even buy the class of degrees that they get, is that really a filter?
It is a filter to a degree. The fact that you can manipulate the university system is of concern, but it is not such a serious concern. If a person buys a degree and gets a 2-1, that's one thing. But you cannot buy third class. At least that reflects your ability. It's one thing to say that the 2-1 may not reflect that person's ability, but it's another thing to say that the third class doesn't reflect the ability. It does reflect. We really need to take a good look at our recruitment. There is no doubt that you can at least begin to address some of the problems by stipulating a minimum, maybe 2-2 or second class lower or second class up. But I know that in many systems, like the English context, it's very difficult to see how you could appoint someone as a judge who does not have at least a second class upper. But by the time, there's no law that says that, but that's just as a matter of convention and practice from the pool of applicants. That is the minimum that all the applicants would possess. And when you are recruiting from that type of pool, you're bound to get better, more robust lawyers.
But that doesn't solve the issue of corruption.
It doesn't, no. So our problems are many. First, you have incompetent people who lobby to be judges, and therefore they get there because some person has lobbied for them. And once you have gotten there on the back of lobby, you cannot be independent.
The arguments for special courts keeps coming up again and again, and recently the acting president announced plans to designate some specific courts to handle corruption cases as part of judicial reforms. Do you think that that would help?
I think there are contexts in which special courts might assist. If, for example, you have specialist litigation where you require specialist technical knowledge, it's best you appoint people with that knowledge because it will speed up things. So, for example, if you were talking about intellectual property disputes, it's probably going to take a case a few hours if it's being tried by a judge who understands it, who has done it, and who has some experience in it. And you could say the same about banking, about company law. So you get specialists practitioners.
But for public and private sector corruption?
But for public corruption, it's difficult to see that there are particular judges who have expertise in corruption, unless you say general criminal law. But I suspect that what the acting president must mean in that context by specialist court is to take them out so that they are not afflicted with a virus that has afflicted the criminal and civil justice system, namely delay, adjournments, and failed prosecutions. And so when you have a specialist court where that court is handling a portfolio of cases, all of which are involved with corruption, the expectation or the hope is that that would speed things up and will make things work better.
So you say that as part of solutions, we need a judicial will and a political will. And under the judicial will, you've talked about looking at the process of appointment and looking at the process of promotion. Political will?
I think the politicians must understand that they will play according to the rules. You cannot operate in a system where the politicians who dominate the country as legislators, as members of the executive, refuse to obey the law. I find that at every level of the legislature and the executive, there's general disdain for the rule of law and the courts. And yet, as soon as they're in difficulty, they run to the courts to get an injunction. And you see that happen time and time again. I see that as simply toying with the courts. There are a number of judicial decisions which both the legislature and the executive have refused to obey. But when it suits them, they come to court. And then they get a compliant judge to grant them an injunction, and then they defend that injunction forever and they take refuge in it. My case is sub judice. You cannot determine it until the case is finished, and it won't finish for 4 or 5 years. And I think that that is very irresponsible and most unfortunate. And it's also unfortunate that the courts fail to see through those ploys and instead allow them to go through by saying, well, you know, we have to conduct our proceedings according to rules. Hell yes, we have to, but we don't have to allow our rules to be abused. And I think in relation to the executive and legislature, the courts cannot enforce their own orders. The Constitution places responsibility on the executive, and they owe Nigerians that duty to enforce the laws. But when they refuse to enforce themselves, there's nothing the judges can do. But that refusal itself is worse than just simply refusing. It shows a disdain for the rule of law, and then signals to the courts that they shouldn't take these people seriously. And so why should the courts be the ones who should be the only serious arm of government if the legislature and the executive fail to perform in accordance with the Constitution?
Well, what can the courts do?
Exactly. The courts cannot do very much in terms of enforcement, but there is no reason why the court should not rise up to the challenge in relation to big cases. As I keep saying, those are the cases that have exposed the courts.
Let's end with the National Judicial Council and the recall of some suspended judges by the NJC. And now we're starting to see charges being filed, and more charges. It looks like we might see more charges being filed in the days ahead. How do you view that recall? Was it a hasty move on the part of the NJC, do you think?
I don't think that there is anything right or wrong about the recall. I think the recall was based partly on the call by the NBA that those judges should be recalled. But I don't know since when the NJC started listening to the NBA or taking directives from the NBA. It's just self-serving to take refuge in the NBA call. At the same time, we shouldn't forget that these judges are lawyers, and so we're all members of the same profession. They are at the bench, we are at the bar, and there's no reason why we should allow them to be kept out of their rules for longer than is necessary. In all the circumstances, at least in the context of Nigeria, and without any further explanation, 8 months did seem to be long enough. As we've seen, some of them are beginning to be charged, but it may well be that it is a recall that was the impetus for the filing of additional charges. And then you ask yourself, why didn't they do so earlier if they had the charges ready? So I don't think that one can fault the NJC necessarily for calling them back after 8 months. I think 8 months would have been long enough. If the executive thought that they were still investigating, it is for them to say, when the NBA passed that resolution, to say, hang on, we are still conducting our investigations and we think that in the next few months we should be done. And in those circumstances, we don't think it is appropriate to recall them yet. But the executive said nothing, and the NBA made the call. The NJC held their meeting and recalled the judges. I don't think that one could fault the NJC. 8 months will be long enough, and certainly some of the judges were charged. But in relation to the judge that was acquitted, discharged and acquitted, it's difficult to see why he shouldn't be recalled by the NJC.
Even though there is an appeal pending, or they say they filed an appeal?
Yes, but I think in the case, there are many issues around that particular judge. In the first instance, the fact that he's acquitted and discharged, that's the status quo, is it not? So he has no charges hanging over his head. On the other hand, there's an appeal against the discharge and the acquittal, and there's an application for stay of execution. And as lawyers, our understanding of the effect of those processes is that you should not execute the lower court's judgment. Certainly where there's an appeal, where there's an application for stay of execution, even if the stay has not been resolved because the argument has not been taken, you cannot then go ahead and enforce the decision of a lower court. The judges tell us that all the time. So the NJC should have known that. That's the first point. The second point, which is of wider significance, is whether, having regard to the fact that this judge had been in the dock and is paraded as an accused criminal, whether in all the circumstances we have not brought the judicial dignity to such disrepute that even on his own, he should not have considered returning until the cloud was completely dispersed. And I think it's because as a people generally, we just have no decorum, no sense of dignity, no sense of what is right, that a judge against whom serious allegations of fraud are made and which are still the subject of an unresolved application for stay of execution and appeal should declare himself victorious and willy-nilly go back to start answering my Lord. But it just shows how low we have fallen as a nation.